So today I'm going to talk about the evolving face of alternate dispute resolution, especially in the Indian context. Over the years, we have seen that several court matters have dragged on for many years. The answer seems to be alternate dispute resolution mechanisms like arbitration, mediation, and conciliation. If I were to talk about the act that governs the arbitration in India, it's the Indian Arbitration and Conciliation Act 1996, which all of us perhaps have read and have used also in some regard. If you look at the Indian scenario, we've seen the Indian economy actually coming of age in the last few years. There is a long way to go as well when you compare us with the global scheme of things. Inevitably, all of this brings business activity and commercial disputes. When commercial disputes emerge, there is a need for a very comprehensive way to resolve that dispute. Therefore, the team that needs to be engaged by the client, by virtue of the highly complex commercial arrangements, as well as in some cases cross-border jurisdictions, and expensive litigation and lengthy procedures, the client needs to actually ensure that in addition to a legal team that understands the specific matters at hand, there is also an expert who understands industry-specific issues as well as the commercial side of things. The role of an expert in dispute resolution cannot be overemphasized. I'll give an example of a mergers and acquisition transaction that went sour between two joint venture partners. Prior to the acquisition, there was a certain set of financial statements that were projected and that were presented. Post-acquisition, the financial statements and the financial results actually went southwards. The acquirer wanted to know what went wrong. Was there window dressing? Was there a case of the business cycle having suddenly gone bad? Therefore, they appointed us. We did the investigation. We also did a determination of the matters at hand and determined that there was a fair amount of window dressing and commercial aspects of the representation and warranties between the shareholders had been contravened. This helped our client actually remove the delinquent management in the acquired company and take control. This matter lasted for about 6 months, during which period the matter helped our client gain significant leverage in the situation. In India, we have seen in recent time amendment of arbitration laws, formation of the national litigation policy, opening of international arbitration councils in India, and qualified international arbitrators being involved in arbitration proceedings. Not only is the awareness about alternate dispute resolution or ADR rising, but it is actively being pursued as a means of resolution. If one looks at the key issues that need to be looked at in an arbitration proceeding and the role of an expert witness, A is a forensic mindset where accounting issues need to be approached in a manner which are consistent with law. Second is leveraging technology, which means using technology like data analytics and digital evidence recovery in a manner that is consistent with globally accepted practices. And a unique skill set, which is a blend of forensic accountants, lawyers, personnel with law enforcement background, and industry experts. All this ensures that an expert is able to add significant value and help the arbitrator take a considered call on the quantum of loss. This actually goes to reduce the amount of time that an arbitration proceeding can take and help a client attain quick resolution. Needless to add, this, i.e., the role of an expert witness, is an evolving one. More and more organizations are beginning to realize the importance. International arbitrations, which are increasing in the Indian context, be it the Singapore International Arbitration Center or the London International Court of International Arbitration, you have several options with regard to both arbitrators and expert witnesses. And these cases are resolved in a quick manner. Thank you.